Well, good morning, everyone. This is George Spees for the Pennsylvania Office of Open Records. Welcome to this morning's webinar, where we're going to be talking about basics of the right to know law. Let's go through a couple preliminaries before we jump into the actual presentation. If you've not attended one of these before, it's essentially a PowerPoint presentation with me speaking in the background. The PowerPoints are available to you on our website, which the URL is on the screen right now. You scroll over to the training tab, click that, go down, and you'll find all of the PowerPoints that we use, excuse me, that we use on these training sessions. You're welcome to any of them. Feel free to download them. Who knows, maybe you could use it for future reference. Maybe you have a friend or colleague who couldn't attend this morning and you'd like to share it with them. Maybe you're conducting some training in the future and you'd find it helpful. Like I said, you're more than welcome to download any of the PowerPoints that we have loaded on the website. This session is being recorded. And again, if you would like a copy of the recording, contact our office, either email or the phone number that's on the screen right now. You'll be put in touch with one of the administrative staff. And usually, I believe what happens is they send you a link that will get you into a secure folder where these recordings are stored. And then again, you would have access to those and you can share them as you see fit. Questions. Use the chat feature. As I'm going through, I will do my best to answer your questions live. But there are two requirements. First is that this session is about the right to know law. So let's confine our discussion to that. And secondly, is that if you can keep your questions as brief and succinct as possible, that would be very helpful. Occasionally, some folks will type in several paragraphs, and it's just awkward for me to sit here and read through it while everyone else is waiting patiently. So the shorter, the better. If it looks like you have something unusually complex to discuss or maybe specific to your situation, we'll do one of two things. I'll wait until the end of the presentation and do my best to come back to it and address it for the good of the order, or we'll take the conversation offline. Again, I would suggest that you would contact the office directly. You'll be put in touch with administrative staff who are very well versed in the right to know law. They can usually get you steered in the right direction. If it looks like you stumped the panel, then the question will get escalated up to our senior staff, and they will do their best to get back to you as soon as they can. I used to say within 24 hours, but lately we've been breaking all kinds of records for appeals and right to know requests that come into the office, and it's just harder. We realize if you're reaching out to us, it's usually something important, so we do our best to get back to you as soon as we can. But you know, we have to work with other deadlines as well. We cannot write requests for you. We can't answer requests for you. We can't discuss active appeals that might be before an appeals officer in the agency. And we can't provide legal advice, but what we can do is steer you towards other cases that we've dealt with where the facts might be very similar, where precedent has been established, that perhaps there's a court decision that will provide you with some useful case law. We'll do our best, like I said, to get you steered in the right direction. So please feel free to reach out to the office if you need some help. Okay. So I believe that takes care of all the preliminaries. Restrooms are across the hall on the right. Let's get started. First thing I want to do is talk about why the right to know law is important. And let's jump into this. First offhand, it just has you know, a much used or overused word today, transparency. Okay, access, transparency, and good government. It's part of where we're headed as a society, and transparency is becoming ever more important. People want to know what their government is up to. All right, so let's put a very fundamental statement on the table. The purpose of Pennsylvania's right to know law is to give the public access to public records. No more, no less. Okay, that's what it's all about. I think it's important to get this out there because, you know, even after 12 years, actually, gosh, 14 years, there's still a misunderstanding about what the right to know law is all about. People see that term right to know and they think it gives them some form of Google for state and local government, and where they can ask any question and then government is forced to run around and find the answer for them. And that's just not the case. And oftentimes when a right to know officer or agency open records officer will call our office and they've got some situation that they just don't know how to proceed, I steer them back to this fundamental statement. And the purpose is public access to public records, okay? They've got a problem, and somehow a public record, they believe, is going to solve that problem. So the right to know law essentially says you can request that record from the government agency. And when I use the term agency, on the state level, I'm talking about, you know, cabinet level departments, boards, commissions, authorities created by statute and the like. At the local level, cities, boroughs, townships, school districts, as a natural extension of school districts would be public charter schools. Again, authorities, any entity created by statute typically falls under the jurisdiction of the right to know law. So we have that in front of us, this law that says the public has access to public records. The starting point is that every agency, every record of an agency is presumed to be public, okay? Now that creates a lot of heartburn for people, especially when they first encounter this law. Someone might be new to the job, or they're working in a government office. They suddenly discover there's this thing called the right to know law, and you think, oh my gosh, everything in the office is going to end up on the front page of the paper tomorrow, or on somebody's Facebook page, or be emailed to all their friends, et cetera, et cetera. And I'm here to tell you that's not the case. There are quite a few tools built into the right to know law that protect confidential information. And we'll talk about that as we get into the presentation a little further. But the starting point is that everything is public unless the agency can make a legal case as to why it's not public. So the burden of proof falls on the agency to show that the record is not public, not the other way around. The requester has no burden, no obligation to prove that it's a public record. It's all on the agency. And like I said, that sounds rather daunting, but when you take a look at the right to know law and other laws that are out there, you're going to find that if you get a request and a red flag goes up and you're thinking, I don't know, I'm just not comfortable giving out this information. I don't think it's right. Chances are there's a tool available that would allow you to meet that legal burden of not having to release the record. But you have to be aware of what those tools are, okay? And if there isn't language that supports that red flag going up, then there's a good possibility that the record, in fact, is public, that you would have to release it into the public domain. All right, so all that being said, let's jump into this a little further. And I want to clarify that the right to know law is not a confidentiality law. Okay, what do I mean by that? Well, for starters, there's nothing in the right to know law that prevents an agency from simply handing out public records. Here's an example. Let's say it's budget season. And within the office, the agency has a stack of budgets, okay? And I come walking in as a member of the public and I say, may I have a copy of the budget, please? Nothing in the right to know law prevents the agency from simply handing me a copy of that budget, and I walk out the door a happy customer. As a matter of fact, even if I have a right to know request, you can say, well, you know what, George? If you tear up that right to know request, I'll simply hand you a copy of the budget. It'll save you a lot of time, and it'll save me a lot of paperwork. Now, why wouldn't I do that? I'm getting what I'm asking for, and you're saving yourself a lot of work, okay? But if I insist, no, I want to follow the right to know process, well, then you have to do that. And, it could mean I'd have to wait for up to 35 days before I even get a response from the agency as to whether or not I could have a copy of the budget. But you can give out public records without ever using the right to know process. There's nothing in there that says you must use the right to know process before you give out any public records. And there's no requirement that you must have a right, that I must have a right to know form, okay? Only if you put that out there, the agency can put out a requirement that any request must be on the right to know form. Otherwise, you can accept a letter, a piece of paper saying, I'd like a copy of this record. It's up to you. The right to know law affords agencies a fair degree of discretion in how they administer their open records program, all right? And whether or not you require a right to know form is one of those areas of discretion. You can require it or you cannot. Our office, believe it or not, we have accepted right to know requests written out on the back of a napkin. But that's just our office. That's how we choose to operate. What we do recommend is that the most commonly sought records that your agency experiences, be proactive. If you have a website or some form of social media platform, take a look at your right to know requests, identify trends. What are people asking for? And then put those records on your website. The right to know law allows you that the next time you receive a request for one of those records, your response can be, that's on our website. Here's a link to the record. Now what happens? Well, it's a little more work up front because you've got to load these documents onto your website. But in the long run, our experience has shown that two things happen. One, the hits on your website will go up because people are looking for the records that they expect to find out there. And two, the right to know requests will start going down. And that's a good thing, okay? That saves you work in the long run. So take a look at things that people are asking for: budgets, contracts, salary information, purchasing documents, and the like. Be proactive, make your website a business platform, and you'll save yourselves a lot of work in the long run. Furthermore, it's what the public expects nowadays. They'd much rather sit in the comfort of their family room on their computer, surfing your website to get the records that they need, to get the information they need, rather than the alternative, which might be having to take an afternoon off from work, come down to the office, file a right to know request, and potentially wait up to 35 days until they get a response to that request, okay? It's just better public service, it's better customer service, and it's more in line with how the public expects to do business nowadays. Okay, question has popped up. 35 days recording the extension. Please confirm the 30-day extension begins with the end of the 5. Yeah, okay, and we'll get into that. But it's 5 business days, 30 calendar days. The 30 calendar days kick in after the 5th, close of business, 5th business day. Okay, moving on. If the agency, and we're assuming you're here, if you're from an agency because you fall under the jurisdiction of the right to know law, there are certain things that you must do. Probably most important is to appoint an agency open records officer, right to know officer. It's the same thing. The two terms are interchangeable. Okay, there's no requirement that this person be at a certain level within the organization. It could be the mayor, it could be the president of council, it could be the school district superintendent, or it could be the nice lady you meet when you walk through the doors and she's there at the counter to greet you. Okay, it must be a public employee or a public official. Furthermore, there's no limit on the number of open record officers you can have within an agency. You can have, for instance, City of Philadelphia, last count, they have 40 open records officers. It just depends on the organization of the agency and the amount of services that they provide. But look at it from the public's perspective. They don't know a lot about the right to know law. You know more, but they have a problem and it needs solved. So their first question is, who do I give this right to know request to? Make it easy for them. Okay, that they know who the agency open records officer is. Now, an agency can come up with its own rules and regulations for administering its open records program. And like I said earlier, the right to know law affords agencies a fair degree of discretion. Let me give you a quick example. Within the right to know law, there is a clause, and I'll paraphrase here, but it basically says agencies may accept anonymous requests. Okay, now because that word may is in there, there's another law in Pennsylvania. It's known as the Statutory Construction Act. And it basically defines what words mean, believe it or not. And that word may also means may not. Okay, so agencies may not accept anonymous requests. Agencies have discretion. They can decide whether or not they're going to accept anonymous requests or whether the person submitting the request must identify themselves. All right, but you need to have that policy in place in order for it to be valid and enforceable. So only one example of a local policy that an agency can have related to the right to know law. Okay, agencies can come up with their own forms, all right? And most of them do. They like to have their seal at the top. Perhaps they have the contact information for the agency open records officers, any of those local regulations that they come up with, et cetera, et cetera. But you must also accept the state form, or what's called the uniform request form. It's on our website. You can link to it. There's nothing necessarily special about it. It's just there. You must accept it if someone comes in with it. And then finally, let us know who you are, okay? Because on our website, we also have a searchable database of agency open records officers across the state, but we realize that, you know, people move on, they retire, they get promoted, et cetera, et cetera. So check out our website, check out the database. If it's not correct, there's a form for you to fill out, email it to us, we'll verify it, and then we'll update the database. Sometimes people will contact our office. I can't find any information. There's nothing on our website. Who do I give this to? So we'll steer them towards the database. Or if we get an appeal in our office, we use the database to reach out to the agency with that appeal information. Okay, questions popped up. Can we require a requester to use the latest OOR request form? We have a couple people using very old forms that don't have all the information on it that the latest one does. Yeah, I think you can do that, Chris. Just, you know, don't be heavy-handed about it. Say, hey, this form has been updated. Do you mind, you know, filing again? You know, provided that doesn't create some, you know, unnecessary burden on them, or if they're worried about deadlines or whatever, maybe you can give them a little bit of slack. But yeah, I think that's reasonable to make sure that they're using the latest form so that all the information is on there. Okay, postings, other requirements of the right to know law. Agencies must have, you know, physical postings. And then if you have a website, you're not required to have a website, but if you do, then you have to have information on your website about the right to know law. And again, the whole purpose is to educate the requester. If you're successful in doing this, you're going to make your job a lot easier, and you're going to make the requester a lot happier. Okay, so the postings, contact information for the ARO. Remember what I'm saying. who do I give this request to? Okay, contact information for the applicable appeals office. Well, 95% of the time, that's going to be the Office of Open Records. My recommendation is that you put the website address, the URL for the Office of Open Records as the contact point, because you can file appeals right on our website and it feeds into our docketing system. Okay, that's how we prefer it. That's the easiest way to do it. Okay, a form in case they don't have one. Okay, your right to know form. And again, if you're using the uniform form, if you're just linking to that, that's fine. Okay, you can do that. But you have to have a form available for them to use if they don't have one and you're requiring it. Okay, and then let them know about any of those local regulations and policies that your agency may have in place as part of the right to know process. Let people know what the playing field looks like before they enter the game, because people hate surprises. They hate new rules and hurdles thrown up in front of them that they're not expecting. So the better you can educate them, the better it's going to work out for everyone concerned. Okay, what can't you do related to the right to know process? Well, first one is you can't have a policy or regulation that limits the number of records that a person requests or the number of right to know requests that they file in any specific time frame. You can't say, man, I'm sorry, you've already filed 3 requests this week. That's all we allow. If she wants to file a dozen, the law allows her to do that. Furthermore, you can't require a person to tell you why they are filing a right to know request. Okay, you can't deny a request based on the reason or what you suspect that reason might be. And the reason might be that they just want to see you work harder. Okay, now let me go off script a little bit and get on my soapbox. The greater majority of people file right to know requests because they have a problem where a record is going to solve that problem. However, I'm the first to acknowledge that there are a handful of people out there who have weaponized the right to know law because the relationship between them and the agency is broken down for whatever reason. Maybe they got a parking ticket. Maybe they didn't like the size of their water bill last quarter. Maybe they just don't like who got elected into office. And they're going to be a pain in the neck. And one of the ways they're going to be a pain in the neck is to file a bunch of frivolous right to know requests. Okay. My experience, before I became a consultant, I was the chief of training for the Office of Open Records. I was also the agency open records officer for the Office of Open Records, handling over 1,300 right to know requests a year. My experience when you're dealing with problem requesters is that the solution is on the payment side of the right to know law. Now, we do a webinar on right to know law and payment issues. I would suggest if you're dealing with one of these people, sit in on that webinar, and I think you'll be educated and it will prove helpful. All right. Enough said about that for now. Let's get back on script here and move on. Okay. I like to describe the right to know process as an obstacle course. And we got the Olympics coming up here, so it's even more germane. Receiving a they pay me to talk. Receiving a request is like the start, okay? And then you've got deadlines. Now, I'm not sure how familiar you are with high-level competition, but typically there's some sort of time standard. Most of the athletes who are racing in the Olympics can't just show up and say, this is what I want to race today. Rather, they have to meet some sort of time standard. They have to be, fast at a certain level before they even allow them to enter the Olympics. That's very similar to the deadlines that we're dealing with. And I want to warn you that the deadlines built into the right to know law are hard and fast, okay? There's no wiggle room. The courts say, this is what the law says, so So this is how we do it, okay? There's no flexibility with these deadlines. All right, and then on this obstacle course, there are 2 hurdles that the athlete needs to jump over. And in front of the second hurdle, there are 3 hoops that they need to go through. Only when they go through the 3 hoops successfully can they jump over the second hurdle. And at that point, we're saying it's a public record and we're granting your request. All right, so let's dive into this and see how this all works. Now, when an agency receives a request, the agency open records officer immediately needs to note the date that the request is received. Why? Well, because one of the first deadlines kicks into place. And it is that the agency has 5 of its business days to provide an initial response. Okay. What does that mean? Well, a business day typically is Monday through Friday when you're open for the public's business. But a couple things can change that. Number one, what if there's a holiday? Well, that's not a business day. Obviously, Saturday and Sunday would not be considered a business day. What if we're closed due to a weather emergency? That's not a business day, okay? What if we're a really small township and we're only open 2 days a week? Well, then you only have 2 business days per week. So if I receive a request today, tomorrow would be my first business day, provided I'm open for business. Let's say it's Thursdays and Fridays, all right? So it would be receive the request today, tomorrow would be my first business day, Friday my second, then we go to week 2, Thursday, Friday, then we go to week 3, Thursday. Close of business on the 3rd Thursday would be my 5th business day. That's the deadline for my initial request, my initial response, okay? Then the law says you have to maintain a copy of the request. Right to know law says for 30 days or until all appeals have been exhausted. Now, if your response is under appeal, it's going to be much longer than 30 days. It can be appealed all the way up to the Pennsylvania Supreme Court, which can take a couple of years, okay? But if it hasn't been appealed, right to know law says you can throw everything out after 30 days. But we also have the Pennsylvania Municipal Records Act, which if you fall under that jurisdiction, which would be cities, boroughs, townships, that says hold on to all right to know materials for 2 years. Okay, I'm going to recommend that if you're unsure, follow the Municipal Records Act, and you should take a look at that anyway. It says right to know material 2 years. After 2 years, if it's no longer under appeal, you can get rid of everything. And you should at that point, okay? But the Municipal Records Act, which falls under the jurisdiction of the Pennsylvania Historical Museum Commission, Bureau of Archives and History, it's a good guide for all the records that your jurisdiction probably has in hand. And it provides guidance on, okay, you can get rid of it after this point. Okay, a very good resource. Okay, all right, questions come up. If a request comes in near the end of the workday, what is, well, yeah, I answered that question. It would be tomorrow, regardless of when it comes in. Okay, so if our offices are closed on Fridays in the summer, then don't we count that as a business? You do not count that as a business day if you're not open for business. Okay, would you suggest a school district save request responses for only 2 years also? Yes, I would, Brenda. The Municipal Records Act doesn't apply to school districts, but I cannot find anything that school districts would follow that provides a retention schedule. I think the Municipal Records Act is a good place to start, okay? Just a good general guide. And even though you're legally not required to follow it, I would recommend that as a best practice, unless something comes along that is better. Okay, good questions, folks. Keep them coming. All right. Moving on. Oh, let me check, make sure Not missing anything. Okay, occasionally I'm going to scroll over and advance the chat because sometimes it doesn't automatically do that. All right, do we count holidays and weekends for the 30 calendar day extension? Oh, just wait, okay? I just pulled up the slide. Sit back, relax, and listen to me. Okay, okay, let's talk about extensions. Okay, let's say you cannot provide a final response during the 5 business days. The right to know law allows you to invoke unilaterally a 30 calendar day extension. Okay, calendar day is just that. You pull out the calendar and count 30 days. It would include Saturdays, Sundays, and holidays. All right, a calendar day is different than a business day. All right, so in order for the extension to be valid, though, there are conditions that need to be met. It has to be invoked within the 5 business day window. You can't wait until what would otherwise be the 6th business day, suddenly realize, oh my gosh, I forgot about this right to know request. Well, we'll just take an extension. Unfortunately, when you missed your deadline on the 5 business days, you denied the request by default. Legally, it's what we call a deemed denial. So keep an eye on the calendar, okay? It's important. You have to notify the requester in writing that you're taking the extension. And if they submitted the request by email, responding by email is fine. You need to provide a reason why you're taking the extension. And you can go to section 902 of the law. There are 6 reasons. You simply choose the ones that apply. All right. Then you provide a date as to when the person can expect to get their final response. Typically, it's the 30th calendar day. And then you provide an estimate of any costs that they're expected to incur. It's just an estimate. It's not a hard quote. You settle up on the exact amount, when you provide the actual records. So you got the 5 business days and then the 30 calendar days tacked on to the end of the 5 business days. All right, questions are popping up here. In our office, Fridays are half days. How do we calculate the days for this? Okay. There is no case law that deals with half days, but I would argue that a half day is considered a business day. You're open for business, accessible for the public. That's a business day. So I would count that. Eventually, it may get appealed up to the courts. If they provide a more definitive answer that disagrees with what I'm telling you, then I'll provide a different answer at that point. But until that happens, my recommendation is half days of business day. Out of office message on my email stating I am out of the office and the request will be deemed received upon my return. Yeah, well, that's going to happen whether you're dealing with a half day or not, okay? And that has to do with the fact that the calendar starts ticking when the request is received by the agency open records officer. So if you're out of the office on vacation, use your out of office reply. That's excellent. To notify the person that their request, the clock will start ticking, calendar will start ticking when you return to the office. Okay. And if you're interested in case law on that, it's Donahue versus the Office of the Governor, which you can find on our website in the case law index. Okay, good points. Moving on. Let me get a sip of coffee. Okay, so we're on this obstacle course. We're now up to the first hurdle. And we have to answer a question in order to get over this hurdle. Is it a record? Okay. All right, well, what does that mean? Whenever I'm trying to explain a law to someone, or they're trying to understand a law, I recommend that they don't forget to read the definition section. Right to know law is no different. It actually has a definition of a record. Any information, regardless of its physical form or character, that documents a transaction or activity of an agency and is, et cetera, et cetera. Okay, key phrase highlighted. Documents a transaction or activity of an agency. What the heck does that mean? Essentially, a record must be about what the agency does, okay? It needs to reflect the business of that agency. Well, why wouldn't it, okay? It's because all day long we generate communications that don't have anything to do with what the agency does, all right? Some examples. I send a text to one of my coworkers. Hey, did you hear a new restaurant's opened up downtown? Let's meet for lunch tomorrow. Or an email to some of the staff. What do you guys think about the trades the Eagles have been making and how it's going to affect their season this fall? Or I'm going to pick up a gallon of milk on the way home. All right. All common communications, none of which have anything to do with the workings of the Office of Open Records. Thus, they do not rise to the definition of a record. And they don't make it over that first hurdle. If someone were to submit a right to know request for all of my emails, those communications would not be included. They're not considered responsive because under the right to know law, they're not records. Okay, you understand that. So I don't have to worry about stuff like that being given out in response to a right to know request because they're not records. Okay, you get that? You see how it works? Now, let me change things up a little bit just for the good of the order here. Let's say I'm at home and I'm on my personal laptop, sitting in my family room, and I send an email using my personal Gmail account to a coworker. Let's say it's Nathan Byerly, the Deputy Executive Director. And, okay, hey, Nathan, I'm doing a presentation tomorrow, or I'm doing a presentation next week, and I'm researching this particular area of case law. Can you have one of the analysts send me a summary on any recent cases dealing with, and, I outline it, okay, and I send that off to Nathan. All right, now, just because I'm at home on my personal computer, on my personal Gmail account, does not excuse that email from discovery under the right to know law, all right, because I'm talking about business of the Office of Open Records, all right? Even if I were using my cell phone to send it, that would not remove it from disclosure. All right, one of the very first court cases coming out of the right to know law basically said you cannot use personal devices and personal accounts to hide the public's business. All right, so that doesn't mean it's illegal. It doesn't mean it's unethical in any way. And there's nothing to prevent you from doing that, from using personal devices. Just be clear that those messages are discoverable because it's based on the content of the message, not how the message was created or where it's stored. Okay? Just so you understand that. And that applies to public officials as well as public employees. Okay? So now we go to the second hurdle. And that particular message or that particular challenge is we have to answer the question, is it a public record? Okay, notice the difference. First one is record, second is public record. And in order to get to that point, though, remember, we have to go through 3 hoops, okay? And let's take a look at those. The first hoop, we have to answer the question, do any exemptions apply? And if so, are we going to invoke them? Okay, what's an exemption? Okay, well, you would go to section 708B of the right to know law, and you're going to find 30 exemptions. An exemption is a definition of a record that an agency may withhold at their discretion. And if you look at these exemptions, they cover an incredibly broad scope of records. And when you dive into it, you realize, well, yeah, this makes perfect sense. I would never give out information like this to the public. Some examples, 708B1, it basically says if by giving out this record, we would put someone in physical danger, we can withhold it. There's another one that says we would not give out a record that would jeopardize the security of our computer system. There's another one that allows you to withhold health records. There's another one that allows you to withhold records of a minor, okay? All stuff that typically would be considered confidential. So the right to know law says you can withhold these if you want to. All right, now it also says that you can give them out if you want to. Okay, the right to know law, like I said earlier, affords agencies a great deal of discretion. It doesn't say, remember when I said right to know law is not a confidentiality law? This is a good example where the right to know law says an agency may withhold any record where an exemption applies, but it also says you have the power not to invoke the exemption if you don't want to. Okay, so you can give it out if you want to. All right, so that's the first hoop. Is there an exemption that applies? And if it does apply, are we going to invoke it? If not, then we can go through the first hoop. All right, but then we come up against the second hoop, which is a lot more stringent, okay? Here we have to answer the question, are there any federal or state statutes or a judge's order that make these records non-public? Meaning, are they confidential by the nature of another law? So you have to be familiar with what these other laws are. And sure enough, we do a webinar on other laws that make records confidential. Here's a quick example. Police departments, okay? Now, typically, they would withhold a record based on 708B16 in the right to know law that deal with criminal investigatory records. But what if it's not an investigatory record? What if it's an intelligence record? Nowhere in the right to know law does it mention intelligence records, okay? But there's another law in Pennsylvania known as the Criminal History Records Information Act, CRIA, that covers a fairly broad universe of records that can only be shared with other law enforcement agencies. They cannot be released to the public. And if they are released to the public, there could potentially be criminal sanctions against whoever does that. So CRIA says you cannot release criminal intelligence information. All right. It doesn't say you may not. It doesn't say you may release them. It says you will not release them, which is different. Okay. And it removes any discretion that the right to know law would otherwise give the agency. So based on this hurdle, or I'm sorry, based on this hoop, even though you could release it under the right to know law, CRIA says, no way, okay? CRIA meets the agency's legal burden for saying we're not going to release these records. Hope you understand that, okay? Another example would be health records, all right? Now, clearly, it's covered by the right to know law, but the right to know law gives the agency the discretion to release them if they want to. You get into the alphabet soup of federal laws, HIPAA, ADA, FMLA, and the like. They say you will not release health records, and if you do, we're going to come down hard on you, okay? Any number of things could happen as far as sanctions. So the agency doesn't have the discretion to release health records, even though the right to know law says so. And if there is another law that says these records are confidential, that trumps the right to know law, okay? You go to section 306 and the language is there. Right to know law will not change the nature of a record as defined by another law, okay? It defers to those laws, okay? And then we come up to the third hoop, where we have to answer the question, is it protected by privilege? Okay, and here we're talking about, for the most part, attorney-client privilege. Attorney-client privilege is any communication between an attorney and their client. And for our purposes, it would be the solicitor and the mayor, president of the council itself, senior management, whatever. Any sensitive information, any sensitive record would be protected by attorney-client privilege, would not be released to the public. Okay. And that could apply to invoices, depending on the nature. Yeah, questions come up, invoices. Would invoices from our solicitor be protected? It depends, all right? If by noting the detail of the invoice, you can discern legal strategy or some form of legal advice, the answer is yes. However, if the invoice is simply listing billable hours and you cannot discern any sort of legal strategy, then I would argue that they would not be protected under attorney-client privilege. Now, if there's any doubt, I would recommend talking to the solicitor and go with what they say. And if the requester disagrees, they can appeal it, and our office will sort it out. Okay, but that's the general rule of thumb that I use. Okay, questions come up. Are draft documents exempt from disclosure, even if the final executed documents are being disclosed? Oh my. Okay, you've gotten into Section 708B10, which deals with internal pre-decisional records, all right, which is probably the muddiest exemption in the right to know law. And I'm going to say we look on those on a case-by-case basis. There is a fair amount of case law on that, but it's not a black and white issue. And I wish I could give you a definitive answer, but for the most part, if the record is internal to the agency, hasn't been shared outside of the agency, and it's considered a draft, it can be withheld. But there are exceptions, and you're going to have to look at the case law in order to really get a good answer on that. Yeah, and until we have a larger body of case law, I can't give you a definitive answer. But again, good questions. Invoices for utilities. Can we black out account numbers as private? Again, here it's not specifically mentioned in the right to know law. It doesn't mention account numbers. There is a limited degree of case law, not a lot. My advice, okay, and this is unofficial, it's not legal advice. Say, if you have a concern, black out the account number, and it can be appealed. Okay, and if you lose on appeal, it's no harm, no foul. Okay, I would take the shot. I would black it out for reasonable reasons. All right, but if an appeals officer disagrees, then they've got a good reason for saying that, and then you release the account number. Okay, but it's up to you. Is there a particular case you can direct me to? So pre-decisional? No, I can't, because there is an evolving body of case law that I would take a look at, and they deal with different issues. There was a really good case, I think last year or 2 years ago, with the Pennsylvania Department of Community and Economic Development. You might want to take a look at that. I think it was the Chester Water Authority. That's the most recent big case on 708B10 I would take a look at, but there may be some since then that I'm just not familiar with. But you got to look at all of them to gain a better understanding on that, not just one case. All right, let's move on, okay? Yeah, okay, so if we made it through the 3 hoops, we can now jump over the second hurdle, and we're basically saying it is a public record and we're granting your request. Okay, that's your response. Simple copy. Let's talk about payment issues, because before you release the records, the person might owe you some money. All right. And this is also another very misunderstood area of the right to know law. A lot of people think the right to know law is free, and it's not. Okay. The right to know law allows you to charge for giving out records in certain circumstances. And we actually, like I said, we do a webinar on payment issues in the right to know law. All right. Well, here's some things that prove helpful. First, is that the agency is only required to provide the record in the current medium. Okay, this is language paraphrased out of Section 701. Let me put it in English, okay? Medium is hard copy versus electronic. Okay, so it means that for our purposes, agencies don't need to scan records in if they're not already in electronic medium. Okay, you got that? You don't need to scan records in if they're not already electronic. Let's say we're dealing with building code issues, okay, and building permits. It's a completely paper-driven process. Someone wants to put up a deck, okay, and your municipality requires they file for a building permit. Okay, the paperwork comes in, it's all paper. The codes guy looks at it, he reviews it, he's got some questions, he sends a letter back to the contractor or whatever, the response comes back, and another letter, and everything, the permit gets issued, that's a piece of paper, goes out the door, everything gets filed in a file folder, put in a file cabinet. Someone files a right to know request, and it comes in email, and they say, I'd like to see all of the permit information on this particular issue, and I'd like it sent to me electronically. And they do that for two reasons. One, it's easy. Two, there's no charge for electronic records, all right? But everything's paper. Remember what I said, based on Section 701, you don't have to scan it in if it's not already electronic, okay? It's up to you. You can scan it in if you want to, but there's no charge for electronic records. Just by the way, Office of Open Records, if we got something like that, we would scan it in and send it to them because it's easier. Just, you look at what's the cost of an appeal versus how easy would it be to scan it in and send it to them. We scan it in and get it out the door. But that's just us. You don't have to do that. All right. Then there's another thing that you need to be aware of. Inspection. Okay. Right to know law allows a requester to get a copy of the record, or they can request to see the record itself. So they submit a right to know request that says, I want to inspect the records. The agency is in the driver's seat as far as inspections are concerned. The agency determines when it's convenient during their business hours for the person to come in and inspect the records. The agency can supervise the inspection. Okay, you can sit there and watch the person to make sure they don't alter a record, they don't destroy it, they don't steal it, whatever. Okay, agency's in the driver's seat. However, if the person pulls out their cell phone and takes a picture of the record, they're allowed to do that, okay, because it's a public record. Okay, so they can make their own copies. They can even bring a copying machine into the office as long as it's not disruptive to the office's operations, okay? Now, you can't charge for labor, you can't charge a redaction fee, and you can't charge for any sort of legal review, okay? That's just considered the cost of government doing business. You can only charge for what's considered an actual or a pass-through cost, like postage, okay? Let's say a person has requested hard copy records and they want them mailed to them. Well, you can charge up to 25 cents a page for single-sided, black and white, 8.5 by 11, 8.5 by 14. And then you put everything on your postage meter. Let's say it's $3.15. Well, you can add that $3.15 onto the invoice, okay? And then send it out the door and collect the fees as you deem fit, okay? You've kind of gathered this from my spiel here, no surprises. Educate the requester. Let them know what to expect, okay? So that they're not caught off guard and they don't get their back up with you. Okay. Let's say you get a request. Do a quick estimate. What's this going to cost? Then pick up the phone or send them an email. Hey, I think this is going to run you about $30. Is that okay? Do that before you start working on things. All right. Because they may have the mistaken belief that everything's free. It's like, whoa, wait a minute. No, I'm not going to pay $30. I'm withdrawing my request. Okay. Or they might say, yeah, that sounds reasonable. Go ahead. At least now you know before you get stiffed after doing a bunch of work, okay? Now, ideally, you do a mutual exchange, okay? But the right to know law says that records are provided upon payment. That means if push comes to shove, the person pays first, then they get the records. Now, here's another common misunderstanding. People believe that the deadlines apply to providing the records. It's not. There are no deadlines in the right to know law that require you provide the records within a certain time frame. Those deadlines apply to the response, okay? The response is provided within 5 of your business days. The response is provided after the 30 calendar day extension. Okay, let's say that you grant the request within the 5 business days. So you would provide a response saying, we're granting your request. We'll provide you with the records after you send us payment and your check clears. Okay, reasonable period of time. Okay, now what's reasonable? Well, that's subjective, but we're assuming 2 to 3 days after the check cleared, you send out the records, okay? And that's how it works, okay? The deadlines apply to the response, not when you actually provide the records, okay? Just so we're clear on all that. Now, there is a provision within the right to know law that when you receive a request, if you do a quick look at it and you realize, oh, this is going to be a big response and it's going to exceed $100, you can demand payment for the entire response up front, okay? I like to refer to this as a security deposit, okay? And the right to know law is basically saying you're not going to get stiffed for preparing this large response without having some money up front. So you do your estimate, you think, okay, this is going to exceed $100. As a matter of fact, we think it's going to cost $200. So you respond back before you even begin processing the request. Let the requester know that and say, we're going to require that you give us a check for $200, which we will hold until all the records are prepared, and then we'll settle up on the exact amount. Okay, it could be more, it could be less, but we'll settle up on the exact amount. Okay, and that allows you to kind of have that security deposit on hand. And then the final thing I want to cover with this slide is that really it deals with non-payment. Okay, now let's say someone submits a right to know request. There is a cost involved. Okay, and you process the request, let them know, you send out the invoice, and you never receive payment. Well, under the right to know law, there's a provision that says you hold on to everything for 60 days. And if they fail to pay, first offhand, if they fail to pick the records up after 60 days, you can discard those records. You can shred them, throw them out, whatever you need to do. Okay, and then if there is a cost involved, though, that cost does not go away. Okay, even though you did everything you were legally required to do, and then you discarded the records after 60 calendar days, the cost is still out there. So how do you deal with that? If the person comes in after the 60 calendar days they still owe you the money. Plus, if they still want the records, they have to submit a second right to know request. And if there's a cost with the second right to know request, they're going to have to pay that. So they have to pay for the first right to know request, and they have to pay for the second right to know request. And you can withhold the records until all costs are paid. Now, what if they no longer want the original records? Like I said, the cost does not go away. So they submit a second right to know request for a completely different set of records until that original cost, let's say it's $30, is paid. You don't have to process the second right to know request. And there's no statute of limitations on this. It doesn't go away after a year. It doesn't go away after 2 years. It doesn't go away after 10 years. All right. If the cost is still out there, you do not have to process any further right to know requests for that individual. Now, bear in mind though, if you're refusing to process any further requests, that's considered a denial. It's basically called a denial for non-payment. Okay, and a denial can be appealed to our office. So make sure all your I's are dotted, all your T's are crossed regarding the denial for non-payment. Make sure you've calculated the costs appropriately. Make sure that all your communication with the requester is documented and so forth, because the appeals officer is going to want to see that, okay, that your denial is appropriate, okay, and in 98% of the cases, they will agree with that, okay. Okay, some questions has popped up here. I have to scroll back because of the other questions coming in. Let me make sure I get that. Okay. If we have a large request that will be in excess of $100 copies and we require prepayment, are we able to wait to pull the records until prepayment? Yes, yeah, you can. The language of that particular section, Chris, is that you can suspend processing the request until you receive the prepayment. Okay, again, it's that whole security deposit approach that you don't get stiffed for doing the work, making the copies until you receive the security deposit. Okay, Roxy, in the past, if they were not charged for a similar request ahead of time, can you still require a check upfront now? Yes. Okay. You've not established any sort of legal precedent by not requiring payment in the past, okay? You can begin anytime you want to. Just make sure you do it for everybody, okay? Don't pick and choose who you decide to charge for, okay? Do it for everybody if you're going to do it for one person. Section where the law says we do not have to process a request if they owe money. My solicitor could not. Yeah, it's not so much in the law as it's a part of case law. Again, go to the Office of Open Records website, go to the final determinations database, okay? That is the database that holds all of the decisions that the Office of Open Records has ruled on. Now, it's in excess of 30,000 decisions. Okay, and you will find them all in that database, but it's searchable. And I would say go to the random text string, put in the word fee, okay, and you'll get all of the decisions where someone has appealed based on non-payment, okay, or put in the term non-payment, something like that. That'll come up. And like I said, it's based on case law. Not only the final determinations database, but you'll also find higher court decisions. Best source is probably the Commonwealth Court. Go to the case law index on the website and go through that, and you'll find decisions based on non-payment. And I think that'll prove helpful to your solicitor. Okay, do I have them all? Yeah, okay, let's move on. Okay, Let's say that the person didn't make it through the obstacle. Oh, another question has popped up. Can agencies shorten the length of time that they maintain records such that any request for information is denied because the records are not maintained? Let's say longer than 3 months. Are the rules around how long agencies are required? Yeah, that's a really good question. It deals more with retention as opposed to the right to know law. But I'll just answer this off the cuff. Okay, don't take this as written in stone. If an agency is either required or has adopted to follow the Municipal Records Act, then that act applies. Okay, if, however, they have adopted a retention schedule where the deadlines are shorter, then, and they're not legally required to hold on to records longer, then that is okay. Okay, if they have on their own adopted their own retention schedule, that is acceptable. And then let's say they dispose of a record after 3 months, then they no longer have the record. It's not in their possession and they're not required to provide it. And let's say that were to be appealed, the appeals officer would simply ask for, or the agency would provide information on the retention schedule. And because it was adopted by the agency and it's documented somewhere that it was adopted, that would be usually is sufficiently from a legal perspective to prove why the agency no longer has the record in their possession because they got rid of it, okay? And that's perfectly acceptable. Just thinking here if there's anything I need to add. I don't think so. It comes down to the whole idea of possession. An agency is only required to provide records within its possession. And if it has a retention schedule that says we get rid of records after 3 months, and there's nothing else that says we need to hold on to them, then that will meet a burden when an affidavit is submitted to the appeals officer saying why we no longer have the record, okay? We're getting into the weeds here with that, but it's a good question. And hopefully it helps explain to people why an agency doesn't have to hold on to a record forever. If you have a retention schedule that says we get rid of them, and we recommend you have retention schedules, then you can get rid of it and you don't have to worry about it when a right to know request comes in. You simply say, we no longer have that record, okay? All right, moving on to this slide. Let's say you haven't made it through the obstacle course and you're denying access to the record. Well, there's a format that you use. Let's talk about this. First is that, I'm sorry, I got a little distracted here with something. Okay, I understand. First, you describe the records that the person is requesting. You're thinking, why would I do that? Well, you wanna frame the issue, okay? Because there may be a misunderstanding as to what the person is actually asking for. Maybe the request is vague. Maybe they're not an attorney, but they play one on TV, okay? And you can't really, so you say, this is what we think you're asking for. Then you provide the legal and factual grounds as to why you're denying access, okay? Remember at the beginning when I said the agency bears the burden? Well, this is where the rubber hits the road. This is where the agency meets that burden. It describes why you can't have these records. It could be that you're requesting the passwords to get into our computer system. Well, if we gave out the passwords, that would compromise our computer system. And 708B, I think it's 2 or 3 of the right to know law says we don't have to do that. So we're invoking 708B 2 or 3 of the right to know law as the legal basis for denying access. All right, and then you put the name, title, information for the arrow, because that's the person legally responsible for responding to right to know requests. the date of the response, which is important because now another deadline kicks in, and then the procedure to appeal to the applicable appeals office. And that is, in most cases, you have 15 business days to file an appeal with the Pennsylvania Office of Open Records. Okay, that would be your denial letter. Now, what if they choose to appeal? Well, they have 15 business days, and now it's 15 of the Office of Open Records business days. We're an independent agency, but we follow the state's holiday calendar. So use that, the person uses that as a guide, but basically the requester has 15 business days. The agency doesn't have to worry about it, okay? Because they would have denied the request, okay? So the requester has 15 business days to file an appeal with the Pennsylvania Office of Open Records. All right, what happens if they file the appeal? Well, hopefully they did it online, and our agency will look for 4 elements. A copy of the original request, a copy of the agency response, provided there is one, a statement as to why they believe the records are public, and a statement believing why they think the agency is wrong. All right, if any of these 4 elements are missing, our agency will issue what's called a deficiency order. And we give the person like 2 or 3 days to correct the deficiency. If they don't, the case gets dismissed. If they do, the case gets docketed. All right, what happens when a case gets docketed? Well, it gets assigned a number, it gets assigned to an appeals officer, and we send notices to the agency and the individual that we have an active appeal. Okay, now, that notice contains instructions on what the agency needs to do. And because the agency bears the burden, the requester, for the most part, can sit back and watch. It's the agency that needs to meet the burden. So, if you are here today and you are an agency open records officer and you receive notice of an appeal, this is probably the most important piece of information I'll give you here this morning. Run, do not walk to your solicitor's office and let them know that you have an active appeal. Okay? Everything I have described in the presentation up to this point is what I'll describe as administrative in nature. Once an appeal is filed, that is an actual legal action. Okay, Supreme Court of Pennsylvania has described the Office of Open Records as an independent quasi-judicial tribunal. All right, and putting that into English, we are a court. Okay, and when an appeal is filed, that's when the court comes into play. All right, that's when the court is in session. And because the higher courts require us to respond a certain way, we must require it of you. All right. The Agency Open Records officer is not expected to know how to do that. Okay. It requires certain language be used. It requires certain forms be used. Deadlines come into play. That again, we have no wiggle room. So your solicitor should know how to do this. They become the point person, not you. Don't try to respond to the appeal on your own, all right? For instance, it may be perfectly acceptable in responding to a request to say, we don't have that record, and leave it at that. If you do that in response to an appeal, you'll lose your case because you didn't submit an affidavit, okay, which your solicitor, will know how to do, all right? It must be accompanied by an affidavit, anything you submit to us, in order for us to enter it into the record of the case, all right? But I don't want to get into the weeds here, but don't try to respond to an appeal on your own because you'll lose based on a procedural error rather than having us take a look at the actual merits of the case. And we don't want to do that, all right? So let your solicitor know as soon as you receive notice that you have an active appeal, okay? And then things should go okay. Now, question, if a requester waits until after the 15 days, should the appeal be automatically dismissed? Well, it more than likely will be automatically dismissed. It will be dismissed as untimely. Again, it depends on the calendar and how the administrative staff here in the Office of Open Records counts those days and determines whether or not the deadline has been missed or not. If the deadline is missed, the case ends up being dismissed based on untimeliness. Okay, so what happens? The product of an appeal is what's called a final determination. It's the decision rendered by our office. Okay, these are legally binding final orders. They carry the weight of law. You can find all of them in the database that I described earlier, 30,000 and counting on our website. It's issued 30 days after the appeal is received unless everybody agrees to an extension. Okay, you can also find these on the legal websites. You can even, if you've got the docket number, you can find them just by Googling the docket number. And they look just like the decisions you would see coming out of your County Court of Common Pleas or the Pennsylvania Commonwealth Court. You know, the same format, same language, et cetera, okay? These are legal decisions, binding. However, they can be appealed just like any lower court. Oh, I'm sorry, I should mention mediation. If everybody agrees to it, there is the option of mediation as opposed to the regular process. Sometimes you just get the impression that the people have been talking at each other, but not with each other. If everyone agrees to mediation, we have trained mediators on staff who it could be as simple as a conference call where you get everybody talking to each other and they're able to agree. Okay, it's non-precedent setting. There's no real record of what's agreed to. It's just the parties agreed to, okay, well, we can provide this record, but not this one because, et cetera. Everybody, you know, they kind of reach, you know, a common understanding and everybody's happy. Okay, mediator's done her job or their job and things have worked out. If not, well, then the case gets moved back to the normal process and no harm, no foul. Okay, but I'm just putting this out there. Mediation is available as a potential recourse in case you want to pursue it. Now, our cases can be appealed just like any other court case. If it's a local agency, it gets appealed to the County Court of Common Pleas. If it's a state agency, it goes immediately to the Pennsylvania Commonwealth Court. Okay. You have to do it within 30 days, whether you're the agency or the requester. The Office of Open Records is not a party to the appeal. We are simply the lower level decision maker, okay? But you have to notify us that you are doing the appeal. And then we will monitor the case. We may file briefs. If it's really an important point of law, we may ask to make an appearance before the court. Okay, it just depends on, you know, the nature of the case and so forth. Okay, but just keep in mind, whoever is filing the appeal, you don't list us as a party. The dispute is still between you and the original requester or the original agency. Okay, just to make things clear here. Okay, Kevin, can you describe the affidavit requirement? Well, yeah. Anything submitted into the record by an agency for a right to know appeal must be supported by an affidavit or an attestation. Okay, and let's say we're dealing with non-possession. Someone has requested a record that the agency doesn't have. They responded in the request. We don't have that record, but for whatever reason, the person doesn't believe you, so they filed an appeal. Okay. Well, now the agency, in responding to the appeal, would provide an affidavit. And it would read something like, I am the agency open records officer for XYZ borough. I'm the person responsible for all records kept in our possession. I have conducted a good faith search of all of our records. This is how I searched for it. I contacted all the people who would otherwise be knowledgeable about this record. And I have determined that we do not have this record in our possession. Or, even using the previous example, per our retention schedule, this record would have been disposed of after 3 months. Thus, we no longer have possession of the record. Okay, and I affirm this statement under penalty of perjury, and I sign my name and date it. And the solicitor would submit that to be entered into the record. That can be then accepted by the appeals officer. Okay, so the agency has now met its burden of legally proving it doesn't have the record by submitting the affidavit. If you just send us a note saying, oh, we don't have that, we got rid of it, that cannot be entered into the record, just as if you were filing pleadings in a court case. Okay, that's what you're doing here at the Office of Open Records. Okay, hopefully that gives you a picture as to the affidavit requirement. Or another document called an attestation, which is very similar, can be accepted into the record as well. Okay, that kind of describes it. All right. Okay, we are at the end of the presentation. All right, but you can still get questions in while I talk about this final slide. And the point being that if I haven't answered your question today, or if a question pops up after we've ended the presentation, take a look at our website. Okay, you've heard me refer to it a couple times. If you sat through previous presentations, previous webinars, you know what I'm about to say. This is the best government website you will ever run across, hands down. Okay, it is updated 6 days a week with new decisions, new court cases, new information on government transparency. There are guides for citizens, guides for agencies. I mentioned the final determinations database, 30,000 decisions and counting that you can search on, legal issue. You can search on your municipality. You can just put in your name and see if that pops up. We have a guidebook for agency open records officers, 78 pages you can download for free, all kinds of helpful information. If you're a real geek about government transparency, you can subscribe to our Twitter feed, or our X feed, I guess it's called now. And every morning we will wake you up between 7 and 8 o'clock with all the news that's fit to print that day on government transparency and decisions that we've rendered, so forth and so forth. Yeah, whatever. I just realized I need to change the Twitter feed reference on this slide. Okay, and you can call our office if you have any questions. Reach out. You'll be put in touch with our administrative staff, and they're more than happy to help you out. Questions popped up. When an agency has a Zoom meeting like yours, is it discretionary for the agency to allow participants to view like you are allowing on this call? It's going to depend on the nature of the meeting, okay? You're getting more into the Pennsylvania Sunshine Act as opposed to the Right to Know law. And we do a webinar on the Sunshine Act at least every other month, if not more frequently. And it's going to come down to, is it a public meeting where they would be required to allow public participation and public observation, or is it simply an administrative meeting? The fact that the public is allowed here on this webinar is purely at our discretion. Okay, we've always allowed the public to attend our webinars. But we do private webinars. The agency is not doing any decision-making or deliberation during those webinars. It's purely for training, educational purposes. So there's no requirement that they open it up to the public. If, however, they were conducting public business, okay, you're saying, yes, it's a public meeting, then I'm going to say under most circumstances, and off the top of my head, I can't think of any circumstances where it wouldn't be required, that if there is an electronic component to a public meeting, that electronic component must be accessible to the public. That is a general rule. There may be some unusual circumstances where that would not be required, but as a general rule, I think that would apply. Yeah, and we'll just leave it at that. Okay, I don't want to give you a definitive answer because we don't provide legal advice, but I think you know where I'm coming from there. Good question. Okay, folks, I think we've wrapped up everything here. Again, good questions from everybody. And another question. Do all submissions need to be supported by an affidavit? Yeah, Kevin. For the most part, I can't think of when a submission would not be supported by an affidavit. It's just like you were dealing with a lawsuit, and you're dealing with a court. Everything must be submitted in a certain format. You just can't submit files and so forth that aren't supported by some statement saying this is true, this is accurate, and this is our case. Okay. As a general rule, and that if you receive notice of an appeal, that instruction is included in that notice that our office provides. Okay. Now, that only applies to the agency, not the requester. Okay, because the requester doesn't bear the legal burden. All right, it may seem unfair, but that's the way the right to know law is written. And yeah, take it from there. Okay. All right, I'm going to try again. And that's okay, Kevin. It's a good question. I'm going to try again to wrap this up. If you do have any further questions, reach out to the office with the information that's on the screen right now. But hey, thanks. It was a good session and a lot of good questions. You were what we call a hot bench, where the lawyer is getting a lot of questions from the judges, and that's okay. It shows me you're paying attention, and you have a good idea of what we're talking about here. So keep up the good work, and we'll see you on the next webinar in 2 weeks. Signing off now. Take care.